Let's talk a little bit about wills. First, let me introduce myself. My name is Terrell Monks. I'm an Oklahoma estate planning and probate attorney. And wills are an integral part of every estate plan, even if it has a trust. The last will and testament is used to tell the court who should receive your estate and who should be in charge of the estate. And sometimes it even goes so far as to tell the court when the beneficiaries should receive the estate. If you're leaving money to take care of children or disabled persons, it's terribly important. It's urgent that you give the court good, detailed advice on when your beneficiaries should receive. And if your beneficiaries are disabled or might reasonably become disabled due to their health conditions, you probably don't want to give them anything outright. You probably should have the court hold everything in trust for those beneficiaries. If you have a trust, the trust will probably be the beneficiary under your will. But there will be times when something didn't make it into your trust during your lifetime, and we want to use the probate to move your assets into the trust. There are also times when it's very important that we have a probate in order to cut off the time creditors have to make claims against your estate. There are several kinds of wills in Oklahoma. A holographic will is fully in your own handwriting, has to be signed and dated at the bottom, but other than that, there's not a lot of rules. Someone will need to come forward and identify your writing, presumably someone who's familiar with your writing, hopefully someone you've known and has an opportunity to see your writing for many years. If we can't find someone with that qualification, we may have to bring in an expert, which is expensive. That's the simplest form of will, but the typical will has at least two witnesses. They shouldn't be related to you. Don't use your wife, your cousin, your brother. Use unrelated witnesses. They have to be over the age of 18. They mustn't be incapacitated persons themselves. They shouldn't be anyone who's going to receive under your will. It is also helpful if your will has a self-proving affidavit, and sometimes we notarize that affidavit in order to minimize the cost of your probate. So in summary, the will tells the court who receives your assets, when they receive your assets, and who's in charge. It can be as simple as your handwritten note, to whom it may concern. When I'm gone, please give all of my estate to my beloved friend, Robert. And Robert's son, Jeff, will be in charge of the estate as my personal representative. Signed and dated at the bottom. And that would be a perfectly legal will. It would, of course, have to go through probate, but it is a good will. If you have any questions about wills, feel free to call us 405-733-8686.